Michael Bean of Michael Bean Trademark and Copyright Law. He's going to speak to you today about the importance of trademarks. Go ahead, Michael.
Hi, how are you? I just give myself a bit of an introduction.
I've been practicing in the field of trademark and copyright law for 25 years. I established my own firm in this field of law 2.5 years ago. Our office is located at the corner of Frederick and Weber Streets in downtown Kitchener. Prior to establishing my own firm, I was an in-house legal lawyer with Procter & Gamble, and then a partner with the national law firm of Gowling. So that's just a little bit of an overview. We're going to start, we're covering trademark and copyright law, and we'll start with trademarks. And the first important, I think, piece to understand is what is a trademark. And it's important to understand that a trademark is any kind of a mark which is used to distinguish your business from someone else's business or the businesses of others. So that mark can take the various forms. It can be your business name itself. It could be a product name or the name of a service that you sell. It can be a logo. It can be a slogan. And it can also be your domain name itself. That can serve as a trademark also. So a trademark really can take the form, and it's the way it has evolved is that even sounds, certain sounds are considered trademarks as well. So they're any kind of a mark that distinguishes your business from somebody else's. In terms of why is a trademark important? Well, a trademark is a key asset of your business. It's a mark which, as I said before, it distinguishes your business from those of others. And in selecting your trademark, from a legal perspective, there are two important things to consider. And the way I like to look at it is that you consider things from both a defensive perspective and an offensive perspective. And on the defensive perspective, the goal in selecting a trademark is to ensure that your proposed trademark is going to be available for your use and that it will not infringe on the rights of others. That, from my perspective, is the most important thing that you can address in selecting your trademark. Once you've determined that it's available, you can then subsequently move to the offensive, which we'll discuss in a minute. And that's essentially putting yourself in a position where you're better able to stop others from infringing rights in the future. So that's something where you can use a tool that you can use to enforce your rights offensively. So we'll talk about both of these during this presentation, defense and offense, and what is involved in each. From a defensive perspective, a good example to, I've just been getting behind here on my slides, but from a defensive perspective, a good example to think about, which really helps to drive this issue home, is the dreaded cease and desist letter. And it's envisioning a scenario whereby you've just begun to establish your business and presence on the North American market, and one day a cease and desist letter arrives at your door. And in doing so, that letter might well say that your new product name, the name of the product that you've just begun to launch, has infringed the registered trademark in Canada and possibly also the US of let's say a multinational corporation. So we're dealing with a big organization that clearly has rights to the trademark. You've gone ahead, adopted a trademark which infringes those rights without giving any prior thought to the steps that you should have taken to ensure that it was available. And so that letter arrives, and you know, what are the consequences associated with that? Assuming that you are in fact infringing that trademark or trademarks of the multinational company or any other company for that matter, that will give rise to a number of potential consequences. One might be that you'll be forced to withdraw your product from the market. You may be forced to pay a claim for damages, and you may be required to come up with a new name, having spent the last year, you know, developing your previous name, which in and of itself can be very difficult, and also difficult because your products have been associated with a certain name or trademark for a period of time, and then you're forced to then change that. So that's very difficult from the standpoint of maintaining the association of your product in the minds of the consumer or the customer. So then, you know, what do you do in order to avoid that scenario, to avoid the possibility of a challenge to your rights to the trademark? What do you do? What steps need to be taken to ensure that you've at least gained comfort that your proposed trademark appears to be available for your use? The key first step is to conduct a search of some kind to help to try to determine whether the trademark is available. That search may take initially a more of a preliminary form to sort of get in there and do some quick and dirty digging to see what's out there. But ideally, in a more extensive way, as a next step, that you would do a more comprehensive search in all the countries in which you intend to do your business, and that search would encompass a number of components. It ideally would look at the trademark database. It would look at business names. It would look at product names. It would look at the internet and domain names. All of those areas should be properly searched to assess whether or not there's something out there that would pose a problem for you. So any items in any of those areas could potentially pose a block if it was used before your trademark, and your trademark is considered to be confusingly similar to it. With respect to, on that latter point, what is confusingly similar, or what can cause confusion from a legal perspective? And in assessing that, and in looking at the results of your search, you would look carefully to see, look at a number of factors in order to determine whether that previous mark could potentially pose a problem for you. And one would be the visual similarity between that previous mark and your proposed mark. It could be also similarity between the businesses associated with the marks. So it could be the goods and services associated with the trademark, the channels of trade, customers. So in looking at all those things, you try to assess whether or not there's going to be a confusion arising from your choice of trademark with the previous mark. And if there is, you're going to have a problem, a legal problem, as we sort of just mentioned. Now, it's one thing to do a search and review the results, but it's really important that those search results be conducted, and then the results reviewed by someone who's capable of assessing the results and determining whether the proposed trademark is or isn't legally available. And that means a trademark agent or trademark lawyer, somebody who's properly qualified in the field to assess those results. So shifting now to the offense, once you've decided you need a new trademark, you've done your search to assess its availability in the key countries in which you intend to use it, and you need to do searches in each of those countries. And then the next step would be, how do we properly protect it, and how do we put ourselves in a position to allow us to facilitate our ability to enforce our rights in that trademark going forward. And what we would recommend is that, as soon as the search is done and it appears to be available and you're going to go forward with the trademark, get a trademark application filed as soon as possible, in any of the countries in which you intend to conduct your business. The first to file applies to most jurisdictions, which means essentially you better file first and be ahead of anyone else in order to establish your rights to the trademark. In Canada and the U.S., there are certain rights that exist by virtue of your use of the trademark, but filing that a trademark will still establish your priority, and it's particularly in a case where you haven't yet started to use a trademark, but you're proposing to use it. So the simple rule is once you confirm the trademark's availability, or at least it appears to be available, you decided you're moving forward with that trademark, get an application filed as soon as possible in all the relevant countries in which you plan to do business. One important rule to be aware of is called the International Priority Filing Rule, and this is a really important one, really helpful one, from the perspective that most countries of the world subscribe to an agreement, which essentially says that if you file an application for a trademark in your home country, you are then given 6 months within which to file in another country for the same trademark, and be given the original filing date of your original home country application. So the importance of that is that if you file in Canada, for example, if that's your home country, and then you file in the United States sort of within 6 months of your original Canadian filing, you will be given the retroactive filing date of the Canadian application, as long as you file in the U.S. within that 6-month time frame. So what it means is that if someone else has filed their own application for the same trademark after you, in the United States, after you filed in Canada, your home country, but before the end of the 6 months, you can move ahead of it if is provided that you file in the U.S. or any other country prior to the end of that 6-month period following the date of your home country application. So that's a really important one. What does registration do for you? A couple of things. One, it gives you the exclusive right to use your trademark throughout Canada or any other country in which you're seeking protection. And it also provides you with evidence to facilitate your ability to enforce your trademark and claim for damages. So those are two key benefits of obtaining a trademark registration. So as we move forward, and just to give you some perspective on the registration process, it actually takes about a year or so in each of Canada and the United States, and it may depend in other countries as well, but certainly as far as Canada and the U.S. goes, it takes about a year or so to complete a trademark registration. And assuming that there are no significant objections or oppositions to your application. So, but it's important to be mindful of that from the start. And there are a number of components in the process. The first step is that the trademark, certainly in Canada right now, it takes about 6 months before the trademark examiner, the trademark office, and the examiner in the trademark office reviews your application. And at that point, it has a chance to raise any issues or objections. Once you've overcome those, assuming you can, then the trademark gets published in a trademark journal. And at that point, third parties from across the country have an opportunity to oppose your application if they decide that they have a basis for doing so. If nobody opposes, or if you overcome any opposition, then the trademark gets allowed, and the trademark will then issue the registration once a declaration is filed confirming that you're using the trademark. So that gives you sort of a brief overview of the trademark application registration process. I think my sort of final slide on the subject of trademarks is I think summarizes the way I think it's helpful to proceed as far as the trademark process, and that is to think defense first and then offense. The defense is the search. It's making sure the proposed trademark is legally available, And that is, I think, the first and most important step. Once you've done that, then you can consider moving forward offensively to try to get a registration which will facilitate your ability to enforce your rights going forward. So defense first, then offense. I think that sums up my perspective on the trademark process. So moving then to copyright. Copyright is the exclusive right to reproduce an original work, or even a substantial portion of that work. Now, that original work can be literary, like a book, dramatic, like a play, musical, like a song, or artistic, like a drawing. And it's important to understand that copyright does not protect the ideas behind the works, but rather the manner in which those works are expressed. And that's an important distinction, that you can't protect the ideas, but you can protect the way those ideas are expressed. An author of copyright has the an author of a work, an original work, has the moral right to be associated with that work as its author and have its name associated with it, and also to prevent any loss in the integrity of the work. So that's copyright. Who owns copyright? The first owner of copyright in a work is the author of the work, unless that author created the work as an employee during the course of employment. And under those circumstances, the employer becomes the first copyright owner. So the author is always the first owner of the copyright, except if it's produced, the work is produced in the context of an employment relationship, in which case the employer becomes the first owner. Registration. The benefits of copyright registration include a legal presumption of ownership of the copyright, and an improved ability to later enforce the copyright. It is not necessary to get a copyright registered. It does have certain benefits, but the negative is that if you register the copyright, you don't actually register a specimen of the work in question, just the title. So there are some limitations, and the most important thing that you can do, and we'll talk about this in another slide in a second, is to properly mark your work with a copyright statement indicating who owns the copyright and giving notice to others of that ownership. You can assign copyright, but copyright ownership may only be assigned in writing in a written document that is signed by the owner. A waiver, as I mentioned earlier, there are moral rights in a work that are different from the copyright ownership, and those moral rights, as I described before, which essentially are the rights of the owner to be associated with a particular piece of work and the right to protect the integrity of the work, those moral rights cannot be assigned, but they may be waived in whole or in part. In terms of the marking of copyright, this is one of I think the one thing that anyone that's seeking to advise the public of their ownership of copyright and to ensure that they've been given proper notice, one of the easiest and things you can do is to give notice to the public of your copyright ownership, and that involves a statement which includes three basic components. One, which shows the copyright symbol, C in a circle. The second is the date on which the work was created, or if it's already been published, the date of its first publication. And the last piece would be the legal name of the copyright owner. And by giving that and asserting that in appropriate ways in connection with documentation, and then you're establishing that you've given some notice of your your assertion of your right to the copyright and the details of that. So that's that's sort of my overview of some of the key legal principles associated with trademark and copyright protection. I'd be more than happy to answer any questions from anyone now, or subsequent or later on. If you're welcome to give me a call in my office, and I'm happy to assist you or answer any questions you might have. But that's my overview for now, and please feel free to let me know now if you have any questions.
Okay, it doesn't look like there's any questions, so thank you everyone for joining. Thank you, Michael. If you have any questions following, please feel free to contact Michael, or you can email us here at the Chamber. And remember to check the Chamber website for future webinars. Thanks everybody, and have a good afternoon.